Imagine being a secondary teacher at a public school in one of the Australian states. Now imagine that you wanted to become a parliamentarian. Now in fact, imagine that you won an election by having an absolute majority of the preferential votes for a seat in the House of Representatives. So imagine that since you were elected, you decided to resign from your old job as a secondary teacher and just be a parliamentarian. Good, it all sounds good, right? Wrong. Chaos. Imagine if you were found to be in breach of section 44 of the Constitution, and because of that, you were prevented from taking the seat as a parliamentarian. You have resigned from your own job, and now you can't be a parliamentarian. This is exactly what happened to Philip Cleary. Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will talk about the case called Sykes and Cleary from 1992. In our last video, we saw the disqualifications of section 44 of the Commonwealth Constitution. If a person falls in each one of the subsections of section 44, that person cannot be chosen or sit as a parliamentarian, either as a member of the House of Representatives or as a senator. And in section 44(4), we find that there is a disqualification for any person who holds any office of profit under the Crown or any pension payable during the pleasure of the Crown out of any of the revenues of the Commonwealth. That person cannot become a parliamentarian. The case of Sykes and Cleary is analysed primarily against the backdrop of this subsection. So let's look at the facts of the case. The case arises out of a by-election for the seat of Wills in the House of Representatives. A writ for the by-election was issued and the candidates could be nominated until 20 March 1992. But the polls were taken on 11 April 1992. Philip clearly won that election on 11 April 1992 by having an absolute majority of the preferential votes for that seat. Who is Philip Cleary? He was a secondary teacher at a public school in the state of Victoria. He had been appointed to provide permanent educational services since 1st January 1975. So until his resignation in 1992, he had been providing educational services and teaching services for the state of Victoria. But since January 1990, he was also on leave. He took leave without pay. So when the elections happened, he was not receiving any salary, any money from the educational department of the state of Victoria. He was effectively on leave without pay. And so after the confirmation that he had been elected, Mr Cleary decided to resign from his position as a secondary teacher and only become a parliamentarian. So here's what happened. Mr Sykes disputed the polls, saying that Mr Cleary held an office of profit under the Crown. Mr Sykes said that Mr Cleary could not have been elected because he was disqualified according to the Constitution. So the question before the High Court was whether Mr Cleary was really disqualified under section 44 because he held an office of profit under the Crown. The decision of the High Court was that he was disqualified. He was nominated on 20 March 1992. He was elected on 11 April 1992. And he resigned from his teaching position on 16 April 1992. Here's the thing. Section 44(4) exists to avoid the executive, the Crown, from influencing parliamentarians. As the majority of the High Court held, the exclusion of permanent officers of the executive government from the House was a recognition of the incompatibility of a person at one time holding such an office and being a member of the House. There are three factors that give rise to the incompatibility. First, performance by a public servant of his or her public service duties would impair his or her capacity to attend to the duties of a member of the House. Secondly, there is a very considerable risk that a public servant would share the political opinions of the minister of his or her department and would not bring to bear as a member of the House a free and independent judgment. Thirdly, membership of the House would detract from the performance of the relevant public service duty. So the majority of the High Court continue to say that although a teacher is not an instance of the archetypical public servant at whom the disqualification was primarily aimed, a permanent public servant who is a teacher falls within the categories of public servants whose public service duties are incompatible on 3 grounds mentioned previously with the duties of a member of the House of Representatives or of a senator. Mr Cleary then, despite being on leave without pay, still held an office of profit under the Crown. He still had a permanent position as a secondary teacher in the state of Victoria. In fact, the taking of leave without pay by a person who holds an office of profit under the Crown does not alter the character of the office which he or she holds. And here, remember, the Crown can mean the Crown in right of the Commonwealth or the Crown in right of the states. So the fact that he was employed by the state of Victoria and not by the Commonwealth did not change anything. He was still disqualified for holding an office under the Crown. For the High Court, Mr Cleary should have resigned from his position of holding an office of profit under the Crown as a secondary public teacher before nomination. This is very important. According to the High Court of Australia, the disqualifications apply from the moment of nomination. It's not from the elections, not from the return of the writs, from nomination. They said that the words of section 44 say that the person is incapable of being chosen. The disqualifications prevent candidates from being chosen as parliamentarians. And so for the High Court, this means that the choice is made by reference to the state of affairs existing on nomination day, and may well be a reason for concluding that if a candidate is not qualified on nomination day, he or she is incapable of being chosen. There's a lot of criticism on this. Seems like the High Court is favoring public officers who have the money to spend and can take the risks to run for an election. But those that are in more modest public offices, they can't take that risk, so they wouldn't run and become candidates in an election. If they did, they would be risking it all. They would be going all in. And the justice that wrote the majority judgment, they recognized that, saying that the disqualification applying from nomination has the effect of discouraging public servants from standing for election to the Parliament. There is force in the view that the field of potential candidates for election should be as wide as possible, having due regard for the provisions of section 44. However, once it is accepted, and as in our view it must be, that nomination is an essential element in the process of choice, that is the electoral process, the answer to the question becomes inevitable. All disqualifications from section 44 of the Constitution apply from the moment of nomination. Well, the outcome of the case was that Mr Cleary could not sit as a parliamentarian because he had not divested himself from the office of profit under the Crown before nomination. And the ultimate result was that new by-elections had to be held for the seat of Wales because the other 2 candidates were also disqualified. These other candidates were disqualified under section 44(1) because of their dual citizenship. We will talk more about section 44(1) dual citizenship and allegiance to a foreign power in my next videos. Make sure you are subscribed and that you click the like button if you did enjoy this video and you've been enjoying our videos here at Aussie Law. I hope to see you soon. Until then, ciao.